Hello everyone, my name is Dr. Bonnie Holligan and I'm a lecturer in property law at the University of Sussex. I'm delighted to be contributing to the Land Law Voices project. In this video, I'd like to talk to you about unauthorised occupation of land. I'll say a little bit about what I mean by unauthorised occupation shortly, but the aim of the video is to get you thinking about three key questions that I think that unauthorised occupation raises for land lawyers. I don't have any simple answers to these questions, but I am going to suggest that a resilience perspective can inform our thinking here and can be helpful in evaluating the balance that has been struck by English law in this area. The first question that I'd like us to think about relates to the role that should be played by the criminal law as opposed to the civil or private law here. Should someone who occupies land belonging to another without the consent of anyone with formal entitlements be subject to criminal sanctions as well as civil or private law remedies? Framing the question in this way suggests that unauthorised occupation must be a bad thing. It must be something that merits the kind of social disapprobation that usually accompanies criminal sanctions. However, I'd also like us to consider whether we can actually learn something from looking at unauthorised occupation. And in this, I'm inspired by the work of Eduardo Peñalva and Sonia Cachal on what they term property outlaws. So I'm going to suggest that, in some ways, the challenge that unauthorised occupation presents for land law may be a good thing. The final question that I want us to think about relates to the balance that should be struck between protection of existing property rights and we know that property rights are protected in human rights law under Article 1 Protocol 1 to the European Convention on Human Rights. How should these be balanced against the rights that an unauthorised occupier of land may be exercising? For example, the right to freedom of expression or right to protest, which are protected also under human rights law, as well as the right to a home protected under Article 8 covering private and family life. So how should land law deal with this balance? I'm going to look here at the case of Malik and Fassenfeld. I said that I would say a little about what I mean by unauthorised occupation. I'm going to cheat and ask you to think about your images of unauthorised occupation. What do you picture when you hear this term? And where do your images come from? Do they come from the media, from your studies, from your personal experience? Apart from the basic idea that an unauthorised occupier is normally physically present on someone else's land without their consent, I would argue here that there is a myriad of different circumstances that unauthorised occupation covers, and it can't be understood as a single phenomenon. The images that I've chosen here represent some of the range of reasons that persons might be occupying another's land, ranging from political protest, and we can see on the left-hand side of your screen an image of a student occupation at the University of Sussex. The most basic reason why someone might be occupying another's land is to find shelter, either on a permanent or a temporary basis, and this might apply, for example, to homeless persons, to persons living nomadic lifestyles, for example, those in gypsy and traveller communities, to persons exercising recreational rights. The third image that I've chosen on the right hand side of the screen is of a squat in Brighton, and this illustrates the role of unauthorised occupation as both a political statement but also as an alternative housing strategy, as a way of critiquing our existing housing systems and the way of both distributing and organising housing, particularly in urban contexts. So we can see that there's not one single thread that connects all these different scenarios. Unauthorised occupation may involve very different persons, very different types of situation depending on the circumstances. Should unauthorised occupation be subject to criminal penalties? Historically, the act of simply breaching someone else's property rights by going on to their land without consent was not subject to criminal penalties. Before the Legal Aid Sentencing and Punishment of Offenders Act 2012, the relevant legislation, the Criminal Law Act 1977 and the Criminal Justice and Public Order Act 1994, focused on prevention of violence, prevention of disorder that might go along with unauthorised occupation, such as large gatherings or damage to land. It also focused on making sure that unauthorised occupation did not prevent, for example, under Section 7 of the 1977 Act, an intending occupier who had an entitlement to occupy from taking up occupation. So the focus of this legislation was on preventing negative social consequences that might accompany unauthorised occupation, but not on criminalising the actual act of occupying another's lands. However, in relation to residential property, this changed following the enactment of Section 144 of the Legal Aid Sentencing and Punishment of Offenders Act 2012, which made those who enter onto residential property with an intention of occupying it subject to criminal sanctions. I have no simple answer to the question of whether criminalisation is justified here, but it's worth noting that the current government has actually suggested extending this legislation further to cover commercial premises also. We may want to think about who this legislation has affected, and we might want to think about whether it might be possible to achieve the same objective with less drastic measures. Since its enactment, Section 144 has been criticised by, for example, charities who work with the homeless, activist organisations, and also some legal professionals who have been concerned about its practical operation and the extent to which the provisions are fair and workable, given in particular stretched police resources. In terms of extending these provisions further and criminalising those who occupy commercial property without consent, there have been fears that this will further restrict the right to protest and may also affect those entering onto land for recreational reasons, engaging, for example, in camping. I'd like us to think, therefore, about the justifications for imposing criminal sanctions and whether you find these justifications convincing. One justification that's often put forward are delays in and cost of the civil courts but it's arguable that that is a reason to improve the civil process rather than necessarily a justification for imposing criminal sanctions. So do you think it is justified to criminalise the breach of property rights, even if this doesn't cause any other negative social consequences? That's one question that I hope this video has encouraged you to think about. The second question that I'd like to raise relates to the possible benefits that unauthorised occupation can offer both to land lawyers and to society. And here I'd like to draw on the work of Eduardo Penalva and Sonia Katyal, who in their work on what they refer to as property outlaws comment that those who breach property norms give us valuable information, what they refer to as expressive and redistributive challenges. So in terms of property law, breaches of property rights may tell us something about the existing distribution of property. It may also tell us something valuable about the content of our property norms. And they refer, for example, to intellectual property here. It may also, however, tell us something about the organisation of society, for example, in the case of civil rights protests, and this would be what they refer to as an expressive challenge. Why are these challenges a good thing? Because we can learn from those challenges to improve our property norms. For example, in the case of, urban squats, we might take the proliferation of urban squats as an opportunity to look at our systems for distributing urban housing and use this information as an opportunity to improve those systems. The same, for example, with civil rights protests, which tell us something important, whether or not they provide an obvious solution. They can tell us something important about discontent with existing social arrangements. And in an open and democratic society, this is a very useful function, and if we did not allow this, we'd be living in a much more repressive society that perhaps isn't a society that we would want to live in, or that is particularly like our own. So for these reasons, it might be important to have at least some tolerance for property outlaws. Neither I nor Penalva and Katyal are suggesting that we should ignore breaches of property rights or not penalise them at all, but this may be an argument for saying that we should try to allow some flexibility in our systems and not try to entirely eliminate unauthorised occupation, but rather to look at how we can best contain it and use it to improve. Following on from this, I'd like to turn to the third question that I raised about the balance between protecting property and protecting the other valuable things that unauthorised occupiers might have to offer us. And I want to look at the case of Malik and Fassenfeld. This was a case that related to the Grow Heathrow site, where protesters had occupied a site that was going to be used for the expansion of Heathrow Airport. The main legal issue in the case related to whether the owner of the land, Mr. Malik, was entitled to an immediate possession order evicting the protesters who had made a home on the land, and whether the Article 8 rights of the protesters were relevant here. Although the applicability of Article 8 in a dispute between private parties was not fully argued, it was accepted in the case that the Article 8 rights of the protesters could potentially be engaged because they had a sufficient connection with the piece of land in question. However, despite the fact that the protesters were what was referred to as good squatters, they had built good relationships with the local community. The actual owner of the land had used the land for dumping cars, but the protesters grew vegetables on the land, they'd removed rubbish from the land, and were generally accepted to have improved the land. Despite this, and despite their connection with the land, it would only be in the most extreme of circumstances that this would justify interfering with the rights of the owner to a possession order. Lord Justice Toulson refers to Endick and Carrington, and the sentiment also expressed by Adam Smith that the very purpose of government is to preserve property, and therefore in most cases the rights to property under Article 1, Protocol 1 will prevail over any other rights that a trespasser on land may have, for example, under Article 8. So it would be very difficult, despite the positive environmental, social benefits that the occupiers were offering in Malik, to argue that this could justify interfering with the owner's rights to evict them. Again, I don't have any simple answer to whether the decision in Malik was the right one. I'd encourage you to think about that. But I do want to conclude by bringing in here the notion of resilience, something that's become increasingly popular across a range of disciplines in the context of the social, ecological, political challenges that we're facing at the moment. And essentially, resilient systems are generally thought to be those that are open, flexible and diverse, and that provide security through connectedness and attachment rather than exclusion. So in terms of property law, what can a resilience perspective offer us in relation to these questions that I've raised about the role of the criminal law, about the benefits that unauthorised occupation might actually be able to offer, and about the balance between property and other rights that unauthorised occupiers may have. I think a resilience perspective can help us to see that openness in our property systems and some element of flexibility is likely to be a good thing. The most productive response may not be to try to eliminate unauthorised occupation entirely, but rather perhaps we should try to understand unauthorised occupation better and to understand the reasons for it, and to try to use those to improve our social systems and our property norms. Turning back to the questions that I raised at the beginning, a resilience perspective might suggest that further criminalisation would not necessarily be the best response. My concluding message then would be that strong property rights don't necessarily come from removing any possible challenge to those property rights. Strong property rights come from a strong social and ecological structure and through strong social support for existing distribution of property rights. So essentially, in a democratic system, strength comes from listening to people, and that includes listening to unauthorised occupiers and learning from what they can tell us. Thank you very much for your attention to this video. If you'd like to explore any of these themes further, I'd recommend the work of the scholars listed on this final slide. They're all very much worth your time. Thank you very much, and thank you to Chris Bevan for initiating this project.